So an interesting thing happened this week. Following up on information sharing agreements that were entered into between the NLRB, the National Labor Relations Board, and the U.S. Department of Labor, Wage and Hour Division, and a second agreement that the NLRB had with the EEOC, which pertains to claims for retaliation against workers who are seeking to enforce their anti-discrimination rights under the laws in the country. Earlier this week, the NLRB entered into a separate memorandum of understanding with the FTC, the Federal Trade Commission, which oversees antitrust violations, ostensibly in order to foster information sharing in their common areas of interest, which for our purposes includes trying to curb the use of non-compete agreements where they unfairly impede workers from being able to move to better paying jobs. So predictably, the FTC chair lauded the new agreement, stating we're committed, quote, we're committed to using all the tools at our disposal to promote free and fair labor markets in which companies must compete with each other to attract and retain workers. And just as predictably, the U.S. Chamber of Commerce reacted reflexively and said, this move represents the FTC going well beyond what's provided for in the law and what was envisioned by Congress. Now, here's what this means or may mean for employers and employees alike. Apparently, notwithstanding that the DOJ was handed a stinging defeat in USA v. DeVita in Colorado, it was a criminal action where the DOJ sought to hold companies criminally liable under the antitrust laws for their use of non-compete agreements. It appears that these federal agencies are, at least for the time being, forging ahead, trying to use whatever legal means they believe they have at their disposal, whether rightly or wrongly, to try and curb the use and enforcement of non-compete agreements and other restrictive covenants. Thanks for listening, and have a great day.